Hello, I'm Will Inman, a partner with the law firm of Inman. For today's 2-Minute Tuesday, I would like to discuss with you the time limits that apply to a workers' compensation case. We often get calls from people who were injured at work, and unfortunately they have waited too long to contact us, and they have missed the time limits to file their claim. This results in their claim being forfeited. Don't let that happen to you. Also, it is very important to understand that today's video only applies to specific types of workers' compensation claims. It only applies to what are known as accidental injuries. Those are the most common type of workers' compensation claim, where something bad suddenly happens at work and you're injured. Examples are a fall, lifting something heavy and feeling sudden pain in your back, a car accident while on duty, a fall off of a ladder. Also, this video only applies to injuries in Maryland and the District of Columbia, and it does not apply to federal government employees or employees of the District of Columbia government. So, here are the time limits. In Maryland, you have 2 years from the date you were injured to file an employee's claim form with the Maryland Workers' Compensation Commission. This form can be filed electronically online at the Maryland Workers' Compensation Commission's website. Failure to file this claim within 2 years of the date of your injury can result in the forfeiture of your rights. There are exceptions to these time limits, but they are few and far between. You should contact a lawyer as soon as you know you've been injured at work so that the lawyer can file the forms for you. In the District of Columbia, there are actually 2 forms that need to be filed. First, you must file what is known as an Employee's Notice of Accidental Injury with the District of Columbia Office of Workers' Compensation. This form must be filed within 30 days from the date of your injury. Secondly, you must also file an Employee's Claim Application form with the Office of Workers' Compensation, and that form must be filed within 1 year of the date of your injury. As in Maryland, there are exceptions to these time limits. But as a general rule, these forms should be filed within the time limits with the Office of Workers' Compensation. You can file these forms on your own in both Maryland and the District of Columbia, but we do not recommend that you do that. These are legal forms requesting benefits to which you are entitled under the law. These forms should be filed by a legal professional. Please feel free to contact Inman at any time. And now for one of the biggest mistakes our clients tell us about. Note that I said that these claim forms must be filed with the government. In Maryland, it must be filed with the Maryland Workers' Compensation Commission, and in D.C., they must be filed with the Office of Workers' Compensation. Many clients call us and say, my claim was filed. I have filed papers with the insurance company. The insurance company has given me a claim number. My claim's filed. That person's claim is not filed. Filing with the insurance company is absolutely irrelevant. The claim forms must be filed with the government, and the insurance company is under no duty to file the claims for you. You, as the injured employee, are responsible for filing the claim forms with the appropriate government agency within the time limits mandated by law. This is why it is very important to contact a lawyer as soon as you know you've been hurt at work. Again, contact a lawyer regarding these time limits because they can become very complex and depend on the exact details of your case. Thank you.